Hello, my name is Sadie Burnett, and I am a ag business major with an emphasis in pre-law. Today I am going to be covering the self-incrimination clause of the Fifth Amendment. I'm going to try to explain to you a little bit about this law and some of the cases that are relevant to it. So, while this is not an area of law per se, it is a very important part of criminal law, especially if you see cases that are litigated for technicalities, and cases where police misconduct could be a part of it. So, the Fifth Amendment of the Constitution, I'm going to read it to you so that you understand how I found this and where I'm coming from. It says, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." So besides being the longest run-on sentence you've ever heard, it actually covers five different parts of what we'd call rights, or clauses, as it would seem. So number one would be the right to be indicted by an impartial jury before being tried for a federal criminal offense, the right to be exempt for multiple punishments or prosecutions for a single offense, the right to remain silent, the right to have your liberties protected by due process of the law, and finally the right to receive fair compensation for the government when the government takes private property for public use. So these are called the Double Jeopardy Clause, Grand Jury Clause, Due Process Clause, Eminent Domain Clause, and of course the Self-Incrimination Clause, which is what we're covering today. So, the roots of this clause actually began with England in the 17th century, and I'm not going to talk very much about it, but it happened because a Puritan agitator, is what it was called in my research, said that he did not have to answer to the courts because he answered to God. And this translated in America slowly at first, even though most Americans were Puritan. They actually had a almost verbatim description of what the Bible would have wanted, and that allowed torture to get confessions out of people. So the most widely known case concerning self-incrimination clause is probably Miranda versus Arizona in 1966. So I'm sure everyone knows it in this class, but Ernesto Miranda was accused of raping a girl in 1963. When he was apprehended, he was presented with a confession that just required his signature. He was interrogated for 2 hours and eventually made a full confession. The officers did not make Miranda aware of his right to remain silent or his right to representation. He was convicted of the rape. He appealed his verdict, and it was heard by the U.S. Supreme Court. Chief Justice Warren ruled that Miranda's Fifth and Sixth Amendment rights had been violated. However, because of supplementary evidence, Miranda still served 11 years in prison for the rape. But it was a case that changed the course of American law, really. I'm sure everyone's watched Law and Order, and this is where we got the Miranda warning. So if you watch any type of crime show, the Miranda warning is you have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed to you by the court. Do you understand these rights as I have read them to you? And that came from Miranda v. Arizona. And this helps protect, especially law enforcement. It covers that people understand their rights and that they do have the right to not say anything and not self-incriminate. Another case that I found is Dickerson v. United States in 2000. This is kind of a continuation of Miranda, but I felt that it was important because it actually clarified the term admissible a little bit and the term voluntary. So Dickerson was, he moved to suppress a statement that he had given law enforcement before he was read his Miranda rights. So the district court granted his motion. Fourth Circuit Court of Appeals reversed it based on that the statement was admissible because of a federal statute passed to overrule the Miranda warning. Their reasoning was that federal statutes always superseded the Miranda warning. The U.S. Supreme Court reversed the Fourth Circuit's reversal, which is very confusing, and it held that Miranda is a constitutional decision. So it actually elevated the Miranda rights and made it a constitutional level, which means that it cannot be superseded by a federal statute. And that's why I chose that particular case to talk about, because it is a continuation of Miranda, but it does clarify some things that Miranda may have left out. Another case that I found about the self-incrimination clause, and this one is very complicated, so I'm going to give you a very bare bones. It's called Bobby v. Dixon, and I'd never heard of it, but it was in 2011. Two men beat up and murdered another man, and they robbed him, and he was being held, one of the perpetrators, one of the suspects. He was being charged with forgery. He was not read his rights. But when he confessed to the murder, they read him his rights. And this was actually a unanimous verdict when he appealed it from the U.S. Supreme Court. It was unanimous that the police had not violated his rights, because while they were talking about forgery, he volunteered the information about the murder. And that was a really interesting one, because he did self-incriminate, but it was voluntary. And that's, again, a clarification thing. Thank you for listening. I hope you learned something, and have a great night.